Good morning, everybody. I'm delighted that so many people have been able to join us this morning to discuss these important topics of health and social care in the present pandemic. The importance of the topic has been shown by the fact that more than 500 people have signed up for this webinar today. My name is David Locke QC, and I'll chair the session. I'm joined by two of my colleagues from Landmark, who you should be able to see on your screens, Stephen Knafler QC and Leon Glenister, who I'll introduce in a moment. A third colleague, Hannah Gibbs, was supposed to be joining us, but many apologies. She won't be able to join us this morning because of other commitments. Barrister's life, I'm afraid, is somewhat unpredictable, but she will be producing a paper and it will be circulated and available when we put the webinar up on the web next week. To begin with a few housekeeping points, your microphones are automatically muted, so you don't need to adjust your local settings. Secondly, we very much welcome questions throughout the session. I'm told that you can submit them via text in the Q&A session, which will be found either at the top or the bottom of your screens, and then hopefully we'll be able to see them. We'll endeavour to answer as many questions as we can at a session at the end of the talks. If we can't provide answers, we'll try and summarize them for a document to be circulated next week, but we hope you understand why we can't provide detailed legal advice in answer to questions for particular circumstances, because that would be both unwieldy and inappropriate given client confidentiality issues. If your connection is lost at any point during the webinar, please rejoin the meeting by clicking on the original link once more, and it ought to take you back in. So let's begin. Our first speaker is a rising star of the public law bar, who's described in the Legal 500 as being, quote, incredibly bright and able to get to grips with cases very quickly, all of which I can vouch because he's been my junior in a number of important cases where his contributions have always been knowledgeable, astute, and wise beyond his years. Leon Glenister is going to give us an ABC guide now to the alphabet soup of public bodies who are or should be working together in the health and social care field in this pandemic, and to explain the roles that they are or ought to be undertaking. Over to you, Leon.
Thank you, David. The last time I did a seminar with David, I referred to him as the pilot of that area of law, and in light of his headset today, he is taking that more literally, and is perhaps also the pilot of this seminar, leading the way. So many of us working in healthcare are used to dealing with disputes with or involving NHS England, CCGs or local authorities. But what the pandemic has brought about are the profile of other bodies which perhaps many lawyers are less used to dealing with. So what I'm going to do is a trot through of some of the public bodies and individuals that are involved in the response to the COVID-19 pandemic and their legal status. Now, being homebound, my wife thought it would be a good idea to do these 30-minute exercise videos that you get on Instagram that various of the gyms are doing. Sure, that'd be a good bonding exercise for us. And they're quite hard work, and I do recommend them, but the sort of saving grace is a sort of warm-up for 5 or 10 minutes, which is like slightly less intense. So this seminar is a bit like that in this pandemic time. So hopefully some of the things I'm about to say you'll know and will be a refresher. Hopefully we'll learn some new things, and then we'll move on to the more difficult topics in relation to life-saving treatment, etc., which David will talk about, and the intricacies of the Care Act. So what we'll do in terms of how we'll structure this my section, we'll start off with the bodies related to central government, so the Secretary of State, Public Health England, the Chief Medical Officer and other advisors. We'll then move on to NHS bodies, NHS England and CCGs. We'll then look briefly at the responsibilities in public health of local authorities, and then we'll move on to other interested groups who you may have seen in the news or in discourse generally, and I'll focus on NICE and the BMA. So starting with the Secretary of State, and what we'll gather through as my section of this seminar progresses is the centrality of the Secretary of State in responsibility for public health. But the main power in terms of public health is Section 2A of the NHS Act, whereby the Secretary of State must, so it's a duty, take such steps as is considered appropriate for the purpose of protecting the public in England from disease or other dangers to health. And thereafter in that section, there is a list of things that can be done as part of that power. And some of those more relevant to this pandemic are conducting research, providing vaccinations, providing other services or facilities for the prevention, diagnosis or treatment of illness, and providing information and advice. And you'll be aware of many steps which the Secretary of State has taken pursuant to that duty. And for example, one of the more high profile things are the building of the Nightingale hospitals. Those fall within that section, providing other services or facilities. The Secretary of State also has powers under the Public Health Control of Disease Act 1984. This is Part 2A, and you'll note the A, meaning it was inserted after 1984. And it was inserted by the Health and Social Care Act 2008 following the SARS pandemic. So the context was that a pandemic was in mind. And in particular, Section 45B gave the power to the minister to make regulations by making provision for the purpose of preventing, protecting against, controlling or providing a public health response to the incidence or spread of infection or contamination in England and Wales. And as we all sit here at home, we are more than aware that this power has been exercised, and that is the regulation, the Health Protection Coronavirus Regulations 2020. You'll be, I'm sure, aware of those regulations and some legal questions which arise from them. And one of those questions which was originally debated was whether the regulations were ultra vires the statute. And that the Act is quite technical, but to put it simply, what the Act permits is the Secretary of State to make power for groups of persons to limit whether groups of persons who they can have contact with and where they may go. And the idea, or the simple idea, would have been things like planes landing from infected areas, cruise ships. So those groups of people, groups of travellers could be caught by the regulations. But the question is whether it was ever envisaged that a group of persons could be every person in the United Kingdom. And there is some good commentary on that, particularly on the UK Constitutional Law blog and articles by Jeff King. So there is an issue, but it's probably an academic issue rather than a practical one, because obviously no claim has been brought. And it's probably something the court would be less than willing to entertain in any event. There is also guidance that's been produced by the Secretary of State, and there is a difference between the guidance that has been published and the regulations. So for example, the guidance recommends one form of exercise a day. The regulations doesn't put any limit on the numbers of times you can leave the house for exercise. I don't think there's a problem in principle with a difference. It's perfectly legitimate for guidance to set out a gold standard and then the law setting out the minimum standard. But as we've seen in the news, what's important is that the police are aware as to what the minimum standard, i.e. the law, is. The guidance has led to some litigation or proposed litigation, so it's recently been amended to make clear that disabled people can leave the house more than once a day to exercise if so required, and that arose after pre-action correspondence in relation to that. So moving on from the Secretary of State's direct powers, we're looking at Public Health England. And again, this is a body at the governmental level, if we remember the layout which I proposed at the start. Now, Public Health England is an executive agency within the Department for Health and Social Care, and it doesn't have any statutory footing. However, it is a significant body. It has over 5,000 employees, and as the website describes, it has responsibilities for preparing for and responding to public health emergencies, and will provide government, local government, the NHS, Parliament, industry and the public with evidence-based professional scientific expertise and support. But in legal terms, what it's doing is it's carrying out a significant part of discharging the Secretary of State's functions under Section 2A, which we've covered at the outset. So in this particular pandemic, what we've seen Public Health England do is provide guidance. So it has provided the guidance, the stay-at-home guidance, for example, but that actually is part of the Secretary of State's role. It's monitored the number of cases in the UK, it's carried out research into vaccinations and provided emerging evidence. For example, a couple of days ago, it published some research in relation to smokers and COVID-19. So it's part of the Secretary of State's general powers. Someone who has who's come to the fore in recent weeks is the Chief Medical Officer. Many of you will currently know it's held by, well, that post is held by Professor Chris Whitty, who appears alongside Boris Johnson or Dominic Raab or whoever is giving the daily briefing. Now, this role is, again, a role within the Department of Health for Health and Social Care. It's a historic role that was created in Victorian times as an advisor to the government. Again, that role doesn't have any statutory footing, but it falls within the more general powers of the Secretary of State in relation to public health. And the role has two limbs. One is as a medical advisor to the government, and the other is actually local authorities have to have a director of public health, and Chris Whitty, or the Chief Medical Officer, is the head of all of those directors of public health. So he has two roles. Now, this pandemic has created some unlikely heroes, and many of you, I'm sure, will not have heard of Joe Wicks before this time, yet are doing his PE classes with the family each morning. And Chris Whitty is another of those who has taken on some prominence at this time. We can see on Instagram, there is a page called Chris Whitty Crush. And on Twitter, there are people who are making sculptures of Chris Whitty as well. And I'm not sure Chris Whitty himself 6 months ago would have thought he would have had that prominence amongst the general population. So moving away from central government then, and moving on to NHS bodies, starting with NHS England, and this is, we're coming on to the bodies probably more of you are familiar with dealing with and knowing the legal responsibilities. But to recap briefly, the duties are set out in the NHS Act 2006. It has general duties to promote a comprehensive health service, continuing improvement of services, reducing inequality, etc. And those are all set out in the Act. NHS England also has some duties to arrange, so some areas of healthcare, so it has a duty to arrange primary healthcare, for example, and that's again set out in the statute. Moving to the pandemic, it has a duty under section 252A of that act to take steps to secure it's properly prepared for an emergency, which some people have cited recently. But what's quite interesting about public health and NHS England is that in terms of statutory construction, NHS England is in almost all cases excluded from duties relating to public health, because those duties are for the Secretary of State. And that issue was dealt with in the case on the slide, the National AIDS Trust case, which was a claim about the provision of a preventative health drug, which NHS England refused to commission, and NHS England said it was a matter of public health, and that therefore was for the Secretary of State. And that argument was accepted, with Lord Justice Underhill stating Parliament did intend to exclude NHS England from any responsibility in the field of public health. Now, I say in most cases it's excluded, but under Section 7A of the NHS Act 2006, the Secretary of State can arrange for certain functions relating to public health to be provided for by NHS England. And it's in that light there is a published agreement, the NHS Public Health Functions Agreement, which sets out what public health functions that NHS England take charge of. And what the thing that's probably most notable is it has significant responsibility for immunisations. So those are general, but that may be relevant if what comes about is a vaccination for COVID-19. It may be that goes on that same list, so NHS England would have more responsibility, but that's something that obviously only time will tell. Also notable in terms of that agreement is that NHS England has responsibility for public health in secure and detained settings. So it has responsibility for public health in prisons. And that's obviously relevant at this time because of the significant vulnerability of prisoners to COVID-19 and the fact they're closed settings. And there's been a significant amount of writing and litigation about this. I'm involved at the moment in a case in relation to an 80-year-old prisoner with cancer who's at a prison where someone has already died of COVID-19. But then the Howard League for Penal Reform have cited research and made submissions to the Secretary of State in relation to prisons, but it's certainly something that that NHS England will have a part to play in as well. Other NHS bodies, again, many of you will be familiar with the remit of these bodies, but CCGs who are in charge of commissioning health services for those they are responsible for, i.e. those mainly in their area. Its duties, just for reference, are in the 2006 Act, Chapter A2. It has general duties which mirror those of NHS England, and those remain. There's no direct statutory function in relation to public health, but obviously it has, it's in charge of commissioning, so is involved in the process. So it may have an emerging increased role if there is a treatment for COVID-19, for example, that it may commission. That may be something which will involve it more in that area, or even a vaccine, depending on where that vaccine sits in the chain of responsibility. I also make reference to NHS trusts, who are responsible for the delivery of much of health service. So that in the statute, the statutory sections for those are sections 25 to 27 and Schedule 4 of the 2006 Act. So turning from the NHS then to local authorities, local authorities also have functions in relation to public health. Section 2B of the NHS Act states that each local authority must take such steps as it considers appropriate for improving the health of the people in its area. And again, there is a list of things it may do, which is very broad: information and advice, services and facilities, assistance, including financial assistance, and making available the services of any person or any facilities. And I know many local authorities have issued, for example, guidance to various bodies or individuals. Many local authorities have issued guidance to care homes, for example, as to how to manage in this COVID-19 crisis. Local authorities also, just to make you aware, if you're advising them, there's a list of guidance from central government for local government across the range of functions, and much of the guidance is non-statutory. There's no duty to follow it, but it is both helpful and relevant to decisions that might be taken. So just a reference to there and the link for those who are advising local authorities or bringing claims against them. So then moving on to the last sort of limb of bodies, which I set out at the start, and that's other interested parties, essentially a miscellaneous category. I'll start with NICE, so the National Institute for Health and Care Excellence. Since its inception in the late 90s until 2012, it didn't have a statutory basis. However, that changed in the 2012 Health and Social Care Act. when it was put on a statutory footing, and that's in Part 8 of that Act. And that part also sets out its functions in relation to research and has some specific functions in that respect. But what is of note in this COVID-19 crisis, it has released certain guidelines in relation to particular patients, departments. There's some critical care guidance, for example. Now, CCGs and presumably others to whom such guidance could apply, they don't have a statutory duty to apply that guidance, but they do have to consider and understand the guidance and essentially have good reason not to follow it. So in legal terms, it's a material consideration which must be taken into account. And the status of such guidance was set out in the Fisher North Derbyshire case, which I've set out there on that slide if you're looking at that. Last but certainly no means least is the BMA, the British Medical Association, who's taken on, you may have heard, taken on a role in this crisis, and it's the professional body for all doctors. So it has a campaigning function, and you've probably seen this in relation to PPE and testing. Now, David, I'm sure will cover this in more detail, but you may have seen over the last week that the BMA has also released guidance on prioritising life-saving treatment, and that should provide the basis and a good link into David's talk, who will explain that topic in more detail. Hand over to you, David. Thank you.
Thank you very much, Leon. I'm very grateful for your introduction. Over the next few minutes, I'm going to be talking about what the NHS should do in circumstances where the demand for respiratory services exceeds the capacity of the NHS to be able to provide it. And I hope to be able to control the slides in a moment. Yes, this talk arose out of legal advice which I gave to a number of NHS organisations across the country and a number of national bodies who were all concerned with essentially the same problem. And that's this: how will clinicians take decisions about who gets access to critical care support in circumstances where the NHS resources available, which in practice means the number of ventilators and the number of critical care beds, is less the number of patients who need those services. I should stress at the outset that everyone hopes this problem won't actually arise in practice or won't arise across the country. Heroic efforts are being made to expand medical treatment facilities. The number of critical care beds in hospitals is substantially being increased, and I've been involved along with Hannah in designing the governance framework for the new Nightingale hospitals, and they're all designed to avoid this problem arising. But the future shape of the pandemic is unpredictable, and NHS organisations therefore need to plan for the worst case as well as planning to avoid those circumstances. So the crucial question is, how does the NHS take decisions about who can get access to critical care when the capacity is insufficient? And that leads to the questions: can the NHS lawfully ration who gets access to critical care? That is saying to somebody who needs the services, no, I'm terribly sorry, you've got a lower priority. And secondly, can it withdraw treatment from those who are provided with critical care, who are put on a ventilator, but are not progressing, in favour of others who may well progress? Now, these are really difficult issues, and there are no clear or easy answers. And what I'm going to say over the next 15 minutes is only very much an introduction to a really complex topic. But essentially, the questions, dividing up the questions, that they can be seen as follows: can the NHS ration? Is rationing lawful in public law terms? Secondly, would any rationing based on health status amount to unlawful discrimination? Thirdly, would it lead to doctors being prosecuted for manslaughter or struck off the GMC register if a patient dies after treatment is either refused or withdrawn. But underlying all these questions are the problems that if the need for critical care exceeds resource supply, what should doctors do? Because they can't do nothing. The first point to examine is there a problem now? I think the answer to this is no. And this is a picture of the Nightingale Hospital being developed at the NEC in Birmingham. Many of you will have been to the NEC for other functions. This is now being turned into a massive hospital, and of course the Nightingale Hospital in London has been developed, the Excel Centre, and the hope is that that overflow capacity will meet demand. Whether it does or not, though, is unclear. The answer is, I think, nobody knows for sure. Everybody hopes enhanced critical care capacity will meet the need, but no one knows. And therefore the NHS across the country are planning for foreseeable eventualities. And this is sadly entirely foreseeable, as NHS local planning is indicating there may be a real problem. So the questions about how these decisions can lawfully be taken do need to be addressed. As Leon mentioned, the BMA Ethics Committee has produced guidance, and as far as I'm aware, it is the only body which has taken the difficult step of asking the question, how will decisions be made? It's not statutory guidance. I'm a member of the BMA Ethics Committee, and we're very conscious that this is, in a sense, private guidance to doctors issued by a trade union with no legal status whatsoever. But it does represent the views of the BMA Ethics Committee, who are very experienced ethicists, intensivists, and legal experts round the table of 20-odd people. And it also sets out the background in research data, which indicates that this has been a problem in other areas. And on the screen should be the introduction section of the BMA guidance, explaining the issues. 5% of people in Wuhan who were infected were admitted to intensive care, and of those, half of them required mechanical ventilation. What the BMA is concerned about is that demand outstrips the ability of the existing standards, and therefore they suggested that in those circumstances utilitarian considerations will have to be applied, and decisions will have to be made about how to meet individual need will give way to decisions about how to maximize overall benefit. The guidance says that doctors would be obliged to implement decision-making policies, and that some patients will be denied intensive forms of treatment which they would have received outside a pandemic. And indeed, health professionals may be obliged to withdraw treatment from patients to enable treatment of other patients with a higher survival probability. And it recognizes that if the situation arises, doctors, indeed everybody involved, is likely to find these incredibly difficult. But if there is a radically reduced capacity, the question is not whether these decisions have to be made, it's how these decisions have to be made, because they will have to be made. And therefore, a framework needs to be developed so that the decisions makers at the front line, who are going to be doctors, many of whom junior doctors, need to know how they are supposed to take these decisions. The crucial step is triage. And triage is a form of rationing or allocation of resources, of scarce resources, under critical emergency circumstances, where decisions are made about who should receive treatment, and they must be made immediately, because more individuals have life-threatening conditions than can be treated at once. And this very often happens on the battlefield, and army medics are trained in the most brutal form of triage. And their thinking is that priority will be given to those whose conditions are the most urgent, the least complex, and who are likely to live the longest, thereby maximising the overall benefit in terms of reduced mortality and morbidity. And the BMA picks up this theme because what it recommends for its doctors, in the absence of any alternative framework produced by government guidance, is that it will be necessary to adopt a threshold for admission to intensive care or use of scarce intensive treatment such as mechanical ventilation or extracorporeal membrane oxygenation. And relevant factors predicting survival include severity of acute illness, presence and severity of comorbidity, and where clinically relevant, patient age. And those patients whose probability of dying or requiring a prolonged duration of intensive support may well exceed the threshold level, which would not be considered for intensive treatment, though they should of course receive other forms of medical care. So with that grim possibility, I turn to the question as to whether NHS rationing in this context is lawful. And the answer to that is yes. There are a long series of cases where the NHS has rationed treatment predominantly on the basis of financial resources, not on the basis of resources such as the availability of critical care beds, doctors, or ventilators, but nonetheless the same principles apply. And there are two well-known cases set out there, which is the Collier case and the Cambridge Health Authority ex parte B case, which will be known to every medical lawyer because it's the case at which Lord Justice Bingham came up with the seminal passage where he recognized that in an ideal world, judges wouldn't have to make these decisions, but accepted that difficult and agonizing decisions will have to be taken in these circumstances, and those are not decisions for the court. They are decisions for the bodies who are allocated that responsibility by Parliament, which is the NHS. An interesting example of where other rationing issues arose was in the BA case, where a challenge to the Secretary of State's directions prioritising donated organs was unsuccessful. The resource of donated organs, hearts, kidneys, and lungs for those who need organ transplants always is far less than the number of patients who could benefit. And therefore a rationing process applies in organ donation, which is strictly based on the health status of the potential recipients, and a combination of those who are sickest but are able to benefit, and those who are in most need is the system that's managed, but it excludes people not lawfully resident in the UK. And that was unsuccessfully challenged by an asylum seeker, and the case went to the Court of Appeal, and the Court of Appeal upheld the lawfulness of that form of rationing. There's a very interesting and recent decision by Mr. Justice Chamberlain that arose in circumstances where the NHS was seeking to evict a patient because of the COVID-19 crisis. And speaking only a few weeks ago, the judge said, in some circumstances, a hospital may have to decide which of two patients, A or B, has a better claim to a bed, or a better claim to a bed in a particular unit. Even ceasing to provide inpatient care to one of them to leave will certainly cause extreme distress or give rise to significant risk to that patient's health or even life. A hospital which in those circumstances determines rationally and in accordance with the lawful policy that A's clinical need is greater than B's, or that A would derive greater clinical benefit from the bed than B, is not precluded by Article 3 of the European Convention on Human Rights from declining to offer inpatient care to B. Now, Mr. Justice Chamberlain, for those who are not familiar with this newly appointed judge, is a very, very distinguished public lawyer. And there he is putting down a very clear marker that this form of extremely difficult rationing is in principle lawful. And that brings me on to the second area of concern. Having established that in principle the courts have said the NHS is able to ration, the next question is, well, what about human rights? And the answer, somewhat surprisingly to some people, is that there are serious questions of whether human rights are ever actually engaged in NHS rationing decisions. And that arises from a case called Condliff, where I appeared for the Primary Care Trust. And the reason is that there are a long series of European Court of Human Rights cases where the court has refused to use human rights issues to engage with the problems of inadequate state-funded healthcare services. And there's a list of those cases on the slide. The central problem is that it's a matter for each state to decide how much money from taxpayers' resources to put into healthcare, and then how to distribute that money. And if the consequences of those political decisions results in patients not getting care that they would otherwise have the benefit of, that's a consequence of the political decisions about the amount of money put into healthcare, or the priorities chosen for the state healthcare system. And the European Court of Human Rights has been very reluctant to enter these intensely political areas of debate, and therefore has said that they very largely fall outside convention rights. The only possible grounds are Article 14 claims about discrimination, but there are at present, as far as I'm aware, no cases positively on that. And therefore, in general, when we look at COVID-19 questions and allocation of resources, it's probable that European Convention of Human Rights grounds don't assist. The next concern is that doctors will be exposed to negligence claims, because after all, how can a doctor not be said to have not acted negligently if they make treatment decisions which result in their patients having suboptimal medical treatment? Now, the answer to this is not straightforward, but in essence, clinicians working in the NHS can simultaneously make decisions as a doctor who owes a private law duty of care to a patient, and as a public law decision maker who has to take decisions on the basis of rationing resources. And there cannot be legally different rules for each function. So if a doctor makes a lawful public law rationing decision to prefer patient A over patient B, as Ms. Justice Chamberlain indicated in the MB case, you cannot use a separate set of criteria under the negligence rules to say that doctor is acting negligently in failing to provide care to both A and B. Hence, as a matter of principle, doctors should not be able to be sued in negligence for making lawful public law decisions. And part of the reason for that is that the standard of care is affected by available resources. For those interested, there's an academic text called Who Should We Treat by Professor Chris Newdick, Oxford University Press, published in 1985, so it's a little old. But the principles, it seems to me, are very clearly set out at page 187 in a chapter entitled, Are Negligence Standards Resource Dependent? And the answer to that question given by Professor Newdick is, in my view, rightly yes. And there are a series of cases which he cited and other cases which have followed it where the same principles apply. So the summary position on negligence, I think, at a high level is this, that a public law decision maker who takes a decision based on a rational policy which allocates treatment based on a fair allocation of medical resources as between different patients should not be liable in private law negligence for failing to provide a service with resources at a greater level than afforded by the public law decision. And the reason is that a breach of public law duties does not of itself give rise to any liability. and it cannot be reasonable to expect a doctor or other clinical professional to provide additional medical resources to a patient over and above that which the public law allocation decision has determined. It's a bit complicated, it's a bit untested, it's a bit at the boundaries, but as a matter of principle, I would suggest that's the right way to approach these difficult issues. But what about equality considerations? It could be indirect discrimination to discriminate between patients on the basis of health status and likely to recover quickly, because it would be disadvantageous to both the elderly, hence engaging the particular characteristic of age, and some disabled people. Though other disabled people, for example, people with learning difficulties or indeed any disability which didn't engage with their respiratory functions, are likely to have the same underlying capacity to benefit as any other patient. But it's probably a proportionate means of achieving a legitimate aim, namely maximising the number of lives to be saved, which is precisely what Lord Bingham in the Cambridge Health Authority case said health authorities should be doing. There is, of course, in addition, a duty to make reasonable adjustments, and that duty is engaged. But it's hard to know what adjustments can be reasonable where there's no clear evidence base, and the standards will constantly shift depending on the patient needs resources balance and the equation. Obviously, any indirect discrimination or any reasonable adjustments have to be proportionate, and the tests there are set out in the Steinfeld case reference, which is made in the slide. But having been through the issues in detail, it seems to me that that discrimination is likely to be justified if it's under a proper policy. Finally, what about criminal considerations? There has been talk about doctors being required, being prosecuted because if they withdraw treatment from a patient in favour of another. I think the simple answer is that patients would die from their underlying conditions, not because of withdrawal of care. And the detail of that important distinction is set out in the Bland case. Also, no prosecution can happen unless it's in the public interest to prosecute a doctor. And I can't see how it can possibly be in the public interest to prosecute a doctor for the consequences of following a lawful trust priority policy to prioritise NHS resources on those who can benefit both. And for the same reasons, no breach of the GMC code could be made to support an unfitness claim. So in summary, assuming these circumstances arise, the dilemma for those in the NHS planning is not how to respond to the present pandemic, it's whether these terrible decisions have to be made, how these decisions have been made, and whether any decision-making system is lawful. And my overall conclusion is that yes, it will be possible to bring in a lawful process, although it will be phenomenally difficult both to devise that process and for doctors on the ground who have to implement it. So what should NHS bodies do in practice? The first thing is to work with their clinicians to ask and answer difficult questions about how these decisions should be taken if the circumstances arise. Then to develop draft policies and engage with the public. I accept it would be very brief at this point, but they still have duties under section 14Z2 and 242 of the NHS Act. Thirdly, for NHS commissioners and provider boards to consider and adopt policies so doctors know how clinical decision making should follow. And finally, to ensure that frontline clinicians have accurate and up-to-date information about the extent of patient need and immediately anticipated patient need, and the extent of available critical care resources, so that doctors are making these decisions with the best information, which will of course not be perfect, about where they are in that balance between need and availability of resources. But what would be inexcusable? In my view, this is a problem which cannot be avoided. we all hope it won't happen, but it would be inexcusable not to plan to guide doctors at the front line about how they have to take these decisions. I'm next going to hand over to Stephen Knafler to talk about health and social care and the changes which are made by the Coronavirus Act. Stephen is a very well-known and leading silk in the area of social care, and we're very grateful to have the benefit of his views today. Stephen.
Oops. Sorry. Just let me try to control my screen. Yes, thank you. I'm having a few problems there with my screen, but let me just carry on. I'm going to start off with an overview of the new law and with a reminder of what's unchanged. Then I'm going to look at the new guidance and how the government is advising local authorities to implement the new law in practical terms. And there are 4 stages of implementation, or as I call them, 4 lines of defense against coronavirus. And then I'm going to consider 3 practical issues, how assessments of need are to be conducted under the new law, how cases are to be prioritized, and then the potential impact of human rights. So as far as concerns the new framework, it's Section 15 and Schedule 12 of the Coronavirus Act, which amend the Care Act 2014. There is statutory guidance, and all of these references are hyperlinks when you eventually get the papers, and there's a range of non-statutory guidance. And if you Google social care and the coronavirus, you'll very quickly come across the full panoply of guidance that there is. I just wanted to say a quick word about the statutory guidance. Para 18 of Schedule 12 to the Act requires local authorities to take into account any guidance issued by the Secretary of State under paragraph 18, and the guidance that's been issued is the guidance I referred to as the statutory guidance, Care Act easements guidance for local authorities. Now, as Leon pointed out earlier, there's a difference between directions and guidance. Directions from the Secretary of State have to be complied with, guidance has to be taken into account, and Para 18 of Schedule 12 reflects that. It contains provision for the Secretary of State to issue directions. No directions have yet been issued, and it requires local authorities to take into account guidance issued under Para 18, and we have this guidance called Care Act easements. But just a quick reminder of the thrust of the case law in this area. In principle, of course, where local authorities are simply under a duty to take into account statutory guidance, they are in principle entitled to depart from it in an appropriate case. But just a quick reminder that where statutory guidance is clearly intended to be nationally applicable and have a normative effect, a local authority will normally have to have a very good reason indeed, based on local circumstances or the particular facts of a particular case, for taking a different course. And to me, in this particular context of the Coronavirus Act, the reserve power to issue directions is actually a reminder from the Secretary of State that he expects the guidance to be followed unless there are pretty exceptional circumstances. Now, the The Act amends the Care Act 2014 by reducing the duties, and the reductions are generally referred to as the easements. So there are two types of easements. First of all, local authorities are no longer required to discharge their duties to assess needs, make eligibility determinations, undertake financial assessments, or prepare care and support plans. That's the first type of easements. The second is that while local authorities continue to have the power to meet needs, they're no longer under any duty to meet needs, except where three criteria apply. Persons have to be ordinary resident or present and not settled elsewhere. Charging provisos have to be satisfied, and critically, the duty only arises so far as is necessary to avoid a breach of convention rights. And the guidance, though, advises local authorities to, notwithstanding the Act, to continue to exercise their powers as if the Care Act remained in force and for as long as reasonably possible. And then the guidance advises that when that tipping point has been reached, local authorities should continue to assess care and support needs as close as possible to the way they would have done under the Care Act 2014, and to meet them for as long and as far as possible as they would have been met under the Care Act 2014. Now, and I'll sort of unpack that a little bit very shortly. What remains unchanged, principally, safeguarding functions, and those other matters that I set out there, those aspects have remained unchanged. Now, on the face of the legislation, you might think that the nature of local authority decision-making in social care cases changed overnight on the 31st of March in England, 1st of April in Wales. But because of the guidance, which, as I say, is clearly intended to be normative, in practical terms, that hasn't actually happened. As I indicated earlier, the guidance advises local authorities to sort of carry on for as long as possible, as if the Care Act 2014 remained fully in force. And it advises that this can be done in two ways. Firstly, by adopting a business as usual approach, and secondly, by taking short-term measures and exercising flexibilities, which are in the Care Act 2014 and always have been in the Care Act 2014. And I should be really interested to hear what people have to say about this. But as far as I'm aware, and certainly all the local authorities that I've been speaking to are actually still in the business as usual phase, although one or two are thinking of taking short-term measures and using flexibilities. I'm not aware as yet of any local authority that's gone further than that, although some may have. As far as concerns using the flexibilities that are in the Care Act and always have been in the Care Act, I'll just give a couple of examples here in the notes. If you look at para 6.3 of the Care and Support Statutory Guidance, that flags up that assessments can be proportionate and could be carried out in all kinds of different ways, including by telephone, video links, so on and so forth. So that's something that can be done that can be done under the Care Act as it currently stands. Para 10.11 of the Care and Support Statutory Guidance explains in some detail about the flexibility that there is under the Care Act in terms of how needs may be met in different ways. And if you look at Annex B of the Statutory Guidance, the easement guidance, it explains in its view, which I'm sure is right, that under the Care Act as it currently stands, it's possible for local authorities to change the way needs are met, to preside over delays, reasonable and short-term delays in the provision of need, short-term cancellations, all those kind of things that could happen in, let us say, the best run local authority while the Care Act 2014 was in force. For example, even before the coronavirus situation affected us, it was possible you know, for care homes to go bust, to cease business, to have to be taken over, and for short-term measures to be adopted. So those are the first two lines of defence, carrying on as far as possible as things have been. Secondly, by using flexibilities that are already there in the Care Act. So we then come to what happens when that's no longer possible. And the overview of the guidance is that it envisages local authorities applying the easements in two stages. First of all, ceasing formal assessments, so on and so forth. And then secondly, as a last resort, prioritising needs. This is just an overview of what's envisaged to occur. First of all, what I call the tipping point needs to be reached. And secondly, the right process has to be undertaken. So when is the tipping point reached? Well, that's basically when a local authority just can't cope anymore and something has to give, otherwise acute needs might not be met. So it's quite an extreme situation that's envisaged there for any of the easements, both the first type and the second type, to be implemented by a local authority. The process is also set out in the guidance, and it's reasonably detailed. First of all, there's a decision-making process, which is the first bullet point. The decision should be taken by the Director of Adult Social Services in conjunction with a range of other people, in discussion with a range of other people. And the decision has to be carefully recorded. And the guidance indicates that the record should be a relatively formal document, should include the nature of the changes to demand, the nature of changes in the workforce, obviously people falling in and unable to function, steps that the local authority has already taken to mitigate, expected impact of the measures, how the changes will help to avoid breaches of people's human rights at the population level, the individuals involved in the decision-making process, the point at which the decision will be made again. And the guidance makes it clear that when it comes to the second sort of easements, reprioritising needs across the local authority, that decision needs to be reviewed every 2 weeks. So secondly, there are a range of publicity and communication obligations under the guidance, which I've set out, including where prioritisation decisions be made, notification with reasons to the Department of Health and Social Care. So looking into the nature of the easements and how they're to be applied in a little bit more detail, I mean, the overarching principle is that the easements should be applied as narrowly as possible at all times. So so you might think, looking at the Act, based on the Act, that there's a straightforward change from sort of 1 to 0, and that once the Act has come into force, or once easements are needed to be applied, you just go full tilt into all of the easements set out under the Act. But that's not what is supposed to happen under the guidance. You go through the first line of defence, business as usual, the second line of defence, using Care Act flexibilities, and then when the tipping point is reached, you shouldn't go straight to both sorts of easements unless it's absolutely necessary to do so. You should try, if you're a local authority, first of all, to go to the third line of defence, which is applying the easements so as to do everything needed under the Care Act in a streamlined way. So streamlined assessments and reviews of need and care planning. I think what this means is that local authorities will adopt local pro forma assessments, which can be much simpler, much more straightforward to complete than as is currently the case. But these will still be geared to statutory eligibility under the eligibility regs. Reallocating resources, meeting needs differently, reducing levels of personal care, but still, as I understand it, with the view to meeting eligible needs under the eligibility regs under the pre-existing law. So that's the third line of defence, which local authorities are expected to adhere to and cling to for as long as possible. When it's absolutely necessary, one then gets to the fourth line of defence, which is full-scale prioritisation, which is now not meeting all eligible needs, but prioritising which eligible needs a local authority is going to make according to prioritisation criteria. That's the kind of decision that needs to be notified with reasons to the department and that needs to be reviewed every 2 weeks. I'll come on to that in a little while. That does need a little bit of consideration because the guidance doesn't really say too much about this critical aspect of the easements. But I'm going to go back to the third line of defence, assessments, reviews and care planning. The thrust of the guidance is that when the easements are applied, the local authority's procedures should mirror as closely as possible the approach and ethos under the Care Act 2014. The local authority should still respond as speedily as possible. Assessment and care planning should still be person-centred, should still be proportionate. Above all, it should comply with the ethical framework, which I referenced in the first slide. And above all, of course, it should consider convention rights. And what I've done here, and I'm not going to go through them one by one, is just distill from the guidance all the different ways in which the guidance exhorts local authorities to implement a streamlined assessment, review, care planning process under the easements, which sort of mirrors as closely as possible the ethos, the person-centred ethos of the Care Act of 2014. I wanted to say a little bit more about prioritisation because surprisingly, given its central importance and the fact that when local authorities get to that fourth line of defence of prioritisation, things will have got to a very difficult stage. If things do get to that stage, it will be a very, very difficult stage indeed. And surprisingly, the guidance does not give that much guidance about prioritisation, although it may possibly be supplemented by further guidance over the forthcoming weeks. And what it says is the department doesn't propose to advise local authorities on how to prioritise, as methods of prioritisation will be unique to each area. There may be established methods of prioritising in most areas. I'm not sure that's right. And then it goes on to say, local authorities may want to RAG rate their packages. I think that means red, amber and green, rate their packages and have them split between high, moderate and low, so on and so forth. And that's pretty much all it says. So I just wanted to really make a few suggestions about prioritisation. I'll be very interested to see what others have got to say about it. I mean, clearly, when a local authority gets to that state where it needs to start prioritising, the first thing it needs to do is identify how it's going to advise social workers and other care staff to identify people who have a convention need, or to put another way, an extremely high need for care services. That's going to be the first thing that will need to be done. Otherwise, how do you sort of put flesh on the bones and the very bare bones of the central government's prioritisation advice? And I mean, it occurred to me, other people may have different views about this, but I just thought back, and I don't know if anyone else remembers it, I'm sure some people will. Fair access to care services, prioritising eligibility for care and support. So before we had the Care Act 2014 and the nationally applicable eligibility regulations, but it's sort of in this intermediate time, before the Care Act, but after local authorities were pretty much left to their own devices to adopt their own local eligibility criteria, we had this statutory guidance called Care Access fair access to care services. And I was looking at this again the other day, and I just wondered if it might be found to be a useful starting point by some local authorities to inform the way they want to identify different levels of needs. And the old statutory guidance can still be found on the internet if you Google it, and I'm not going to set it all out, but just as a reminder, there were 4 levels, weren't there? Critical, substantial, moderate, and low. And the way, and then under each band, the Department of Health, as it then was, sort of tried to explain its view and its guidance as to what a critical need actually was, and you can see the way they set that out here, and what a substantial need actually was, so on and so forth. And it just occurred to me that some local authorities might find it useful to reflect on those bands and those indicators and those descriptors in fair access to care services when trying to work out what they think, how they think, by reference to what criteria they think local authority services need to be prioritised locally. Now that leaves, I've left to the end, convention rights, and it's necessary to have a think about convention rights because, as you'll all know, and as I indicated at the outset, where there is a convention need, that is a need that there remains a duty to meet under the Coronavirus Act. And one question that a number of people will be asking is, well, does that mean anything at all? And I think it's fair to say that it is very difficult, as David indicated earlier, to gain any traction from the convention in health or social care cases. And I essentially agree with everything that David said when he addressed that topic, but I don't think David was saying that it will never be the case that the convention can be relied on in a health or social care case. And I think he indicated that issues can sometimes arise under Article 14, and I think the Strasbourg court and the courts here have always indicated that in an extreme case, the convention can be relied on, but those cases are quite limited. So just trying to catch up with myself. Well, Bernard and Enfield is the case that for a UK lawyer that they'll probably think of first of all when they think about convention rights in a social care context, because this was, the case in which someone actually succeeded in getting damages under Article 8 in a social care case. Mr. Justice Sullivan held that there wasn't a breach of Article 3 in that particular case, just about. He thought it was finely balanced, but he decided there was a breach of Article 3. But he did decide there was a breach of Article 8 in that particular case, where Enfield had failed to provide Mrs. Bernard with suitable accommodation, and it was for a period of about 20 months. And I say straight away, in the light of the very powerful factors that David has drawn attention to, one has to take Bernard with a health warning, and one can't assume that one can simply apply it in a straightforward manner to the present context. Nonetheless, it was a case where Mrs. Bernard, who was unable to use her wheelchair inside the temporary accommodation she was in, was confined to the living room where she was in a great deal of discomfort. She had no privacy. She was totally dependent on her husband to sort of pick her up and carry her from room to room, including to the bathroom, which was a huge problem as she was doubly incontinent. There was a breach of Article 8. She was awarded 8,000, her husband 2,000. The judge said that she had been left lacking privacy in the most undignified of circumstances, a burden wholly dependent on the family, living in conditions which made it virtually impossible for the family to have any meaningful private or family life. So that's an example of where the convention did have telling effect in a social care case. Of course, which goes to show that the convention can be brought to bear. Of course, that wasn't a case of a local social services authority struggling to contain coronavirus in its care homes and in its temporary accommodation, struggling to deal with staff shortages, so on and so forth. And it's fair to say that whenever you get a convention case where either Article 3 or Article 8 is relied on, the court is going to look very carefully at the context that the public authority in question is grappling with at the time before it decides that there's been a breach of the convention. Anifrieva is a case somewhat similar to Bernard, where Mrs. Anifrieva failed in her attempt under Article 8. It's the case in which the Court of Appeal tried to think about how the convention might apply in a social care context, and essentially decided that for there to be a breach of Article 8 in the social care context, things had to be pretty much as bad as they would be for there to be a breach of Article 3. In other words, the situation had to be inhuman or degrading, or something very close thereto, as it was in the Bernard case. Although the court went on to say in cases involving children, there might be a more claimant-centred approach. In that case, the council had failed to provide the family with suitable accommodation. I think for a couple of years, it's a fairly similar period. The elderly, ill and disabled mother fell down the stairs, became frightened of using them except to come down to use the bathroom. One of the children, grown-up children, fell down the stairs and broke her arm. The mother was unable to participate in family life effectively, was almost confined to her room upstairs, and there was an allegation the council had dragged its feet. She failed. Limberweller, of course, is, I suppose, and it's an extreme example of success. The failure to provide accommodation to late claiming asylum seekers, with the result that they face destitution on the streets, would be a breach of Article 3, if you remember that, quite readily in all cases and straight away if the people concerned were vulnerable. And the big problem in this context, the case everybody has to face up to, is the case that David had referred to quite briefly, Pentiakova and Moldova. I'll just say a little bit about that case. It was a case where Moldova had radically reduced hemodialysis provision in Moldova for budgetary reasons. And that caused huge suffering in Moldova and quite possibly death, but the evidence didn't establish that. And the application complaining that the reduction in hemodialysis treatment had infringed Articles 2, 3 and 8 of the ECHR didn't just fail, it was dismissed as being manifestly unfounded. And the first worrying thing about Pentiakova for anybody approaching this with a claimant focus is that while of course Articles 2 and 3 don't contain qualified rights, like Article 8 is, the European Court concluded that it was unnecessary to address Articles 2 and 3 separately from Article 8. So it effectively treated the whole question as one that was dominated by the question of budgetary resources. And on Article 8, where it gave its reasoned judgment, the court essentially said that Moldova hadn't failed to strike a fair balance between the needs of individuals for hemodialysis and other demands on its budget. And it came up with this statement, which I always read or listen to with quite a chill. What they said is, while it's clearly desirable that everyone should have access to a full range of medical treatment, including life-saving medical procedures and drugs. The lack of resources means that there are, unfortunately, in the contracting states, many individuals who don't enjoy them, especially in cases of permanent and expensive treatment. Now, the European Court was particularly mindful of its status as a supranational court, applying the margin of appreciation that it owes to national authorities. And that doesn't, of course, apply in the domestic context. But I think if you look at the case law, you'll see that national courts here have applied something very, very similar. They've allowed a margin of judgment to national bodies that have to make resource-sensitive social allocation decisions in the health and social care context, which is extremely similar to the margin of appreciation that the national court, the Strasbourg court adopts. So that's the, obviously Pentia-Cova doesn't apply to cases of negligence or carelessness, that sort of thing. It applies to cases of sort of careful decisions about resource allocation. But that's sort of fundamentally one of the big cases for those concerned about convention rights to address. And hopefully it won't come to that. As I say, I stand to be corrected, but I'm not aware of any local authorities that have so far had to apply the easements. That many local authorities I'm in contact with are still at stages 1 and 2, have not applied the easements yet. And if they do, I imagine they will be, I'm sure they'll be, you know, exercising might and main to make sure that the old style critical needs under fair access to care services and all of them are met, you know, all the time. So in conclusion, should it be necessary to rely on convention rights, anyone relying on them is going to face an uphill struggle, but it's not a struggle that is completely impossible to accomplish. Where people are going to have much more success, I think, is in obviously persuading local authorities that their client is in dire need and needs help straight away, and using the guidance, the ethical framework in the sort of domestic law context to challenge decision making. And I think that's where people are going to be able to make much more headway in litigation terms, should it be necessary to do so. So that's all I have to say. Thank you very much for listening. And I'm going to hand back to our pilot, David. Thank you very much.
Thank you, Stephen. Ladies and gentlemen, we've had a number of questions, and what I'm going to do is read out the questions and then allocate them in order to try and get through as many as we can in the next 10 minutes or so. First of all, I'm not going to say who's asked these questions. I won't embarrass whoever's asking them, but a question has been raised that a local care home manager has been told that she must request testing of her staff and residents via the local CCG. But the question is asked, do the CCGs actually have a role or responsibility in relation to making available testing? And the CCGs, we're told, are very reluctant to agree to the testing, and the nearest testing station is at the airport 15 miles away, and many care staff don't even have cars to get there. Leon, I think this is one for you.
Yes, in terms of the responsibility for testing, my understanding at the moment is it's being dealt with by the Secretary of State, and that's consistent with his powers under Section 2A, which I've covered already. And we've seen the mass testing centres being set up, labs being set up. I think Amazon have been involved in some of the production of the tests and various other companies. So it's all being set up by the Secretary of State. I'm not sure the CCG really have a role in that. In terms of the issue at hand, I think the answer is I'm not sure who has told the care home manager that the testing needs to occur. I'm not sure as yet there is a direct requirement in guidance or law that those staff are tested. So to engage and find out, try and figure out a practicable way that you can deal with the issues. I mean, I'm not sure anyone would debate that getting tested is a good thing, but trying to find a way forward.
Stephen, I think you know about the social care context of this.
Yes, I'm not pretending that I can give chapter and verse on this, but one of the pieces of guidance published by the Department of Health and Social Care is called COVID-19, Our Action Plan for Adult Social Care. And page 14 is talking about testing of care workers, and it makes a lot of promises. It says that the government's rolling out testing of social care workers across the country, with over 3,000 workers having been referred to local testing centres. What it says is that the Care Quality Commission is leading coordination of testing. They've already offered testing, it says, to around 11,000 care facilities, quote, and are contacting all registered care providers in the coming days, unquote, and then it goes on. So it may be that this COVID-19, Our Action Plan for Adult Social Care, could be a good starting point for local authorities and social care providers within the statutory framework, within the legal framework that Leon just drew attention to.
Thank you very much. So it may be that this is not CCG, but CQC who have been initiated this, hence the alphabet soup. Thank you. The next question, I think, is directed to matters I said. It said, you said capacity is not an issue. Isn't treatment though already being rationed? And there are multiple reports of people being told they will not be admitted to hospital, and the factor is the management of resources. I don't think capacity should be an issue. In fact, I feel very strongly that capacity should not be an issue around access to resources, and that somebody, for example, who's got learning difficulties or other lack of capacity should not be denied respiratory care, ventilation, on the basis of their underlying other underlying disabilities. And it seems to me that if NHS organisations are adopting a capacity to benefit quickly approach, which is what the BMA guidance recommends, and what I think is in principle an ethical approach, and therefore probably a legal approach, somebody who is 30 with learning difficulties will have exactly the same capacity to benefit as somebody who's learned 30 without learning difficulties. The second issue that's raised is, are people being dissuaded from going to hospitals because of perceived lack of resources? There clearly is lots of evidence that that's happening, though we do need to be careful, because we already have many reports of people who want very elderly people to go to hospital to receive ventilation in circumstances where they probably wouldn't be candidates for ventilation even outside a pandemic, because of the poor prognosis of getting such patients off ventilation. So a balance needs to be struck there, but in principle, capacity should make no difference. That brings me on to the next question, which is about the NICE guidance and the critical frailty framework. NICE have produced guidance, I think I referred to it. It refers to using the clinical frailty framework, and suggests that patients should be assessed, and if they have a CFS score of over 5, then normally they shouldn't be referred through for critical care facilities. So that is to some extent age dependent, because they don't recommend using the critical frailty framework for patients who are under 65, but age discrimination, age is plainly relevant to the prospects of survival, and there's clear clinical evidence of that. Whether that's justified or not is a very difficult and interesting question, and we don't have time to go into that. But what that guidance doesn't deal with the problem that what happens if you have a CFS score of under 5, or you have people under 65, and you don't have enough critical care beds. That's the issue there. One short question about whether resources should be assessed nationally or assessed locally in making the assessments. my understanding is that the NHS will make resources, will assess the resources available to the patient, which could be in that hospital, could be within a wider network. So, for example, in London, that will include the capacity of going to the Nightingale. And obviously, there are very good critical care networks across linked hospitals. But I don't think the fact that somebody in Cornwall could theoretically be provided with a critical care bed in Carlisle is a realistic option. And so it probably will be limited to those hospitals that the patient can reasonably access. Stephen, an issue for you. A local authority has just awarded a care contract on prize only. They've been quite open about this because as far as they're concerned, the easements allow them to do this. As providers, we're horrified at the consequences because quality and sustainability is at serious risk. Is this allowable that price or cost is prioritized over everything else?
Well, sort of just going back to the short answer is probably not. I mean, just going back to the structure of the guidance, the first two stages are business as usual and applying Care Act flexibilities. So I would expect local authority commissioning to continue on the same basis as it has been operated for as long as possible. Now, the first question to be asked of a local authority that says it's entitled to commission differently because of the easements is, well, have you actually applied the easements? I do think, I understand some local authorities are of the view that the easements sort of come into force automatically, but they don't, not if a local authority takes into account and adheres to the guidance. So I think the first question for that local authority is, well, have you actually applied the easements? Have you gone through the decision-making process set out in the guidance? Where's the record of your decision? And where are your notifications? So I'm a little bit skeptical that the local authority in that particular case has actually lawfully applied the easements. When it comes down to the type of situation where the easements have been applied, then yes, I mean, it will be possible for local authorities to streamline and change their procedures. And I suppose commissioning is definitely going to be one of those areas where decision making could be streamlined. But I can't see the rationale for contracting simply on the basis of cost, or how that can be justified by any of the circumstances that have given rise to the coronavirus pandemic. So I'm very skeptical that that could ever be lawful, but one would need to know a little bit more about what was actually going on in that particular area before being definitive about it.
Well, there's a fairly clear pointer there, Stephen. Thank you. A couple more questions. We're running out of time, ladies and gentlemen. I've been asked about public engagement. How can NHS bodies do this, and how can they maximise the impact of usefulness of public engagement here? Seems to me it can only be done electronically. If NHS bodies are adopting these policies locally, which I think they'll have to do in the absence of any national guidance, then they'll have to be published on CCG websites, trust websites, invite electronic responses. Medical directors will have to go on the local radio and explain that this is what they're proposing and ask for the public's views. But it all will have to be done very quickly. But of course, an initial policy can be adopted. It can always be kept under review depending on the public response. The final question, I apologise if this is, there are a number of questions about whether or not the government has published guidance, and the answer is no. The government has not published any guidance for public bodies taking these difficult decisions. And the concerns have been raised by a number of questioners, as that means that there is some form of informal rationing going on against unpublished criteria. I think that must be right. And that is precisely the area where we are concerned, which is why responsible public authorities are moving quickly to try and give guidance to these people making decisions to try and ensure that they are made against a framework. A question has been raised as to whether the case of Papashvili in Belgium rules out Article 3. The answer is no, it doesn't, not on rationing grounds. What else is a doctor supposed to do? You have 2 patients, you have 1 ventilator. You can only ventilate 1 patient. The ECHR does not put public bodies in impossible positions in emergencies. I'm afraid this is a case of where decisions just have to be made, however really, really difficult they are. And the concern is that they're not being made against a proper framework, and therefore all sorts of unconscious bias are coming in. To avoid precisely, as one questioner asked, crude rationing. Ladies and gentlemen, there are other questions that have been raised. I'm sorry we've run out of time. Can I thank you for attending? Can I thank my colleagues and the staff, the Landmark staff, who worked so hard to set this all up. I hope you found it interesting. And we are continuing to work through the pandemic, and we are all available. And as I think has probably been indicated, we're all working with a whole variety of clients from both individuals, families, organizations, and public bodies in order to try and support them in the really difficult decision making that they're having. But I hope you found today's seminar, or webinar, sorry, useful. So thank you very much. Here ends the lesson. Goodbye.